So the Supreme Court has decided that Gemma O'Doherty and John Waters do not have to pay state costs to defend the challenge from the challenge to the COVID-19 measures. My name is Terry Gorry. I'm a solicitor in Enfield. I make videos about Irish law, Irish business, entrepreneurship and that sort of thing. Gemma O'Doherty and John Waters brought a number of challenges, or brought a challenge to the constitutionality of the COVID-19 regulations and laws introduced by the state to deal with the COVID pandemic. Their challenge in the High Court was thrown out and was described as having been misconceived and entirely without merit. The Court of Appeal, where they then brought the appeal from that decision of the High Court, also threw out the case and said it was without merit. They went to the Supreme Court then, and the Supreme Court also threw the case out and rejected their application, rejected their challenge to the constitutionality of the law introduced. However, the Supreme Court has ordered that the Waters and O'Doherty do not have to pay the state's costs incurred in defending the challenge, in defending the state's laws introduced. They said that the Supreme Court case itself, they weren't going to make any order as to costs, and they went a step further then, and they actually set aside previous cost orders from the High Court and the Court of Appeal, and they set those aside. It's estimated that the costs involved would run into a six-figure sum, and the state now has to pay their own way essentially. They cannot pursue costs from O'Doherty and John Waters. The Supreme Court vacated the cost orders made against the applicants by the High Court and the Court of Appeal after both courts dismissed the applicants' action. In arriving at the decision to do so, the Supreme Court recognised that there was no personal gain involved for the two individuals who brought the case, and also recognised that there were issues of importance that should have been or were justified in being brought. Nevertheless, they lost in the High Court, lost in the Court of Appeal, lost in the Supreme Court. The court held that such evidence is required where the legislation challenge recites circumstances as to why it is deemed necessary. In the case raised by O'Doherty and Waters, such expert evidence had not been adduced. So essentially, there was a lot of opinion from O'Doherty and Waters, but no expert evidence. The applicants had challenged the constitutionality of the 2020 Health Preservation and Protection and Other Emergency Measures in the Public Interest Act, the 2020 Emergency Measures in the Public Act 2000 or COVID-19, and the 1947 Health Act. In the judicial review proceedings against the state and the Minister for Health, the applicants sought to have various measures declared unconstitutional and flawed. However, in May 2020, the High Court refused to grant them leave, saying their claims were not arguable, and the appeal was opposed by the state. So there you go. The taxpayer is going to be picking up the tab. Obviously, the state can't get the costs now from O'Doherty and Waters, even if they did have the money, or even if they wanted to pursue them. They're not in the position to pursue them now because the Supreme Court has not given the state the application that it made granted its application for a cost order, and has gone a step further and has set aside the cost orders against O'Doherty and Waters, which were made by the High Court and the Court of Appeal. So there you go. Hope you find this video useful, and you might give it a thumbs up down below if you do, and you may be interested in subscribing to my YouTube channel. Thanks a lot.